But from 1999, there have been evolutionary development, if I have to use that word. But in 2023 elections, we've had the worst of judgments of court.
The Nigerian lawyer and member of the People's Democratic Party, PDP, Daniel Bwala, has said that the electoral tribunals of the 2023 presidential and gubernatorial elections led to the most inconsistent and worst judgments that the courts have delivered in years. Bwala said this in an interview with Arise News on Monday, where he addressed the sack of the Plateau State Governor of the People's Democratic Party, Kenneth Moftwang, by the appeal court in Jos. The lawyer said, in 2023 election, we have had the worst judgment of the court. We have not had so much of conflicting decisions by 1/3 of government. Because if you look at the election tribunal this year, you will notice that there were inconsistencies in 1 or 2 tribunal cases at the trial level. And this is caused by the corruption in the judicial system. Listen to the end of the interview as he speaks.
We have not had so much of conflicting decision by one tier of government, because if you look at the election tribunal this year, you would notice that there were inconsistency in 1 or 2 tribunal cases at the trial level, and then probably at the Supreme Court 1 or 2 complained. But at the Court of Appeal is where almost all of these conflicting judgments that have so far been experienced. And for the records, the Court of Appeal is one court. So even if it were judgment delivered in Maiduguri, let's say division of the Court of Appeal, and it can be relied upon in Lagos as the court, the same court, not that you are addressing their lordships and saying, my lord, your learned brother in Maiduguri decided this. No, my lord, this court, because the court is one. And so surprisingly, you would think that the court should be abreast of the various judgments it delivered and be consistent in its judgment, especially when the judgments are founded on the principles of the law. Facts can differ, but the principle of law is constant. And wherever you turn, when the principle falls on a direction, the judgment has to be consistent and constant. But we have seen conflicting decisions of the Court of Appeal, especially where it affected the People's Democratic Party. And I'll tell you what, there was the judgment by the Court of Appeal in Plateau State that removed the governor. And the appellate court delved into the merit of a pre-election matter, and they said it also qualified as a pre-election and main election, and they delivered the judgment. The same Court of Appeal in Ebonyi State, the case of pre-election was canvassed. The Court of Appeal in Ebonyi said it's a pre-election matter, we do not delve into pre-election. In Benue State, pre-election matter was raised regarding form of INEC. The court in Benue said it is a pre-election matter. In fact, we are guided by the judgment of the Supreme Court. We stay constant in it. In all these places where judgments were delivered, either in sustenance of pre-election matter in tribunal or in the rejection of the pre-election case in tribunal, the beneficiaries have been the People's Democratic Party. Awesome. This is where the concern comes. But you see, Mr. Abati, Section 287 of the Constitution of Nigeria makes it clear the position of stare decisis and judicial precedent, that the judgment of the Supreme Court is binding throughout the Federation of Nigeria on all authorities and courts that are subordinate to it. In this 2023 election, the Supreme Court of Nigeria settled the issue of pre-election matter. In the case brought by APM, in the case brought by APC, in the case brought by Labour, where pre-election matters were canvassed and they were joined together with fundamental provision of the Constitution to suggest to the Supreme Court that this is so germane that you cannot close your eyes from it. And the Supreme Court made strong pronouncement, in fact with anger and vehemence, that anybody who is not a member of a political party, or even if it were a member of a political party, where the case border on pre-election, it cannot be brought that said party is a busybody. I have also heard, Mr. Abati, People said, but in 2019, in Yari's case, the Supreme Court sacked APC. Why is PDP crying? And they failed to realize that in 2019, apart from the fact that it was a decision decided on the old order of both the amendment to the Constitution and the Electoral Act, it was a case brought by a member of All Progressive Congress. It was intra-party matter. In this year, Supreme Court said, you are a busybody to try to question. In fact, they even said, even where the legality of what you are challenging is genuine, it falls short of two things. Number one, time required for the determination of the matter. And number two, the matter is not an election tribunal matter. If you look at section 34, the grounds for which election victory can be challenged is clear. And you will see there is no disobedience to the court judgment as a ground. There is no even the issue, for example, in Plateau State, Mr. Abati, when they say there was no valid Congress, that they didn't even have a structure in the first place that will warrant for them to sponsor a candidate. What is the structure of a party as recognized by law, by the constitution of the parties, and by the various decisions of even the Supreme Court? The National Working Committee is the life, the soul, and the spirit of a political party. When you sue the National Working Committee. As long as the National Working Committee exists, even if there is no any structure at all in a state, it cannot give rise to the decision of validation by the court that there is no conduct of Congress. In the first place, even the order that they raised and said it was violated, the order was obeyed, because the parties that were brought to the court that gave rise to that judgment were not the party that eventually emerged. Before the judgment, there was a new Congress conducted in which new persons emerged. But even delving into the merit, legality, or otherwise of the matter, a pre-election tribunal case have no business, according to the Supreme Court, to even delve into the matter. Somebody may be challenging double nomination. Somebody may be challenging falsification of document. Somebody may be challenging the emergence of candidate not through a valid Congress. Somebody may be challenging the legality or otherwise of the member of that political party. All of them fall within the purview of the pre-election, as clearly illustrated in section 285, meaning that it is a dispute that arose before the declaration of the winner of election. Now, any dispute that arises in a political party, whether during the Congress or during the primaries, there is a time frame for the determination of that suit. And there is a forum which the law says it is the Federal High Court, both in the Constitution and in the Electoral Act, and not the Election Tribunal. The Election Tribunal, according to even Justice Dachijo, is a sui generis. It is a different character. You do not equate the proceedings in Election Tribunal with the proceedings in regular court. An example, if in regular court you're out of time to file any document, and you can file a motion for extension of time to do that. If the other person files counter affidavit to challenge it, the court has always said that where there are two competing motions, the one that would survive that will survive the suit is the one they will consider. So they are always inclined to granting that motion. In Election Tribunal, if the time passes you, even Supreme Court said they cannot exercise jurisdiction to determine the matter. So Justice Dachijo made it clear that the character of a pre-election case, no matter the gamut in which it arises, can never be entertained by Election Tribunal or an appellate court that is determining the question that arose from Election Tribunal. And that is why you find in Benue, they maintain the position that they lack jurisdiction to determine pre-election. In Ebonyi, they maintain that they lack the jurisdiction to determine pre-election. Even in Plateau, they said that it is an election, although we admit that it is Election Tribunal, but we also believe that it is a pre-election because it borders on Section 177 of the Constitution. Now, Justice Nikitobi and the various justices that have served and have retired have always in their judgment classified any decision by a court lower than them that tends to run away from their decision. It is judicial rascality. They say you are embarking on a frolic of your own, because this Constitution, no Electoral Act, says in Section 287, the judgment of the Supreme Court binds all courts in Nigeria, that are subordinate to it. And in this case, it is the judgment of the Supreme Court that said pre-election matter cannot be determined by election tribunal court. In the case of Justice Datijo, who was retiring, what he did was to open up this country to the reality of the fact that the Supreme Court is as human as any other element and is also susceptible to corruption and corrupt practices. These were his words about the way in which people were elevated to the Supreme Court which are not consistent. Anything that is not consistent with procedure or law is corruption. So he was able to, for the people who said everybody should keep quiet when Supreme Court give judgment, he gave us a perspective that it is not all Uhuru. There is a problem in the judiciary and the system in which judges rise up to the Supreme Court, from recruitment and then promotion and all of that. So that's the point, actually. I didn't know he was referring to Datijo, who was retiring. Now, with respect to the reform, and I have no doubt, Mr. Abati, in my mind that the Court of Appeal decision in Jos, when it goes to the Supreme Court, that like the way when we say all eyes are on the judiciary, the people tend to think as if you're blackballing the judiciary. No. When you say all eyes are on the judiciary, you are saying our hope now lies on how they will interpret. So this case of Plateau State, when it goes to the Supreme Court, it will be a case of Supreme Court versus the Court of Appeal. It has more to do with the sanctity and integrity of that Supreme Court itself, because Supreme Court will have to determine whether that judgment they delivered in Presidential Election Tribunal is to be carried out by subordinate courts in Nigeria, because they made it clear, and a court, by a decision by a final court, is called a settled law. Once a law is not determined by the final court, it's not a settled law. But once it is determined by a final court, it is cast on stone. So Supreme Court will have to determine whether the Court of Appeal is above it or that it is above the Court of Appeal. With respect to the reforms, Mr. Abati, in the last 9th Assembly, I serve as the person in the office of the Deputy Senate President. Of course, traditionally, that office handles constitutional amendment. And I began the process, and I remembered extensively the advisory we gave. In fact, the Deputy Senate President was open to some of these reforms that we introduced. We produced a bill. These bills were sponsored in the National Assembly, but as they began to go around Nigeria, some states knocked it down. We provided for pre-election. That is to say, time limit for which Congress matters should be determined and not brought forward to the primaries. Time which the primaries on has to stop, and then you go to election tribunal. So instead of pre-election and election tribunal, we provided for pre-election and then pre-election and the election tribunal, because we do not want a situation where somebody will win an election and then a court will remove him for whatever reason. So whatever question that arose from Congress must be determined before primary start, up to the highest court that has jurisdiction over it. Whatever happens in the election tribunal must be finished before the election. Whatever happens in the election will be determined by the election tribunal. If the 10th Assembly will go back into those reforms agenda, the reform agenda, and bring them forward, it will help. With respect to the Electoral Act, because what we did was, if you leave it at the Electoral Act level, what happened in 2023 will be applied. Where the lawyers and parties went about saying that electronic transmission is merely a guideline because it is not in the Electoral Act and it's not in the Constitution. What we did that time was to put it in the ground norm so that no court or individual can have jurisdiction to nullify it. If the balls, National Assembly will carry the balls to bring this reform, it will be helpful. Now, Dr. Abati, I am a human being. I must express my concern to say whether I believe this National Assembly will carry the reform or not. We will continue to suggest, but whether they have the balls is what I cannot guarantee you. This 10th Assembly is worse than rubber stamp. Rubber stamp is even better, because in the rubber stamp assembly that was stamped in the 9th Assembly, at least they will deliberate, they will debate, at least they will interrogate the executive, but the executive will end up finding their way. Here, this one, they don't debate, they don't interrogate, they don't do anything. You heard from among their members, not external people, that when bills are brought to this house, the speed with which they are passed, and you know the bill passage process, you bring it to the plenary. When it is debated, you submit it to the committee. Committee will hold hearings. Then they will come back to their own committee of the whole before it gets to become. And the procedure for that is so that the Nigerian people will be carried along, because the law is made for the people, not the people made for the law.
Okay.
So reform agenda cannot be successful without removing the INEC chairman.
Okay.
Reform agenda cannot be successful without changing the INEC commissioners.
Okay.
Because majority of the INEC commissioners are members of a political party.
Okay.